Welcome back to the OMB Law Board. I'm Simon Bennett, and today I've got Bailey with me from our property law team. Welcome back, Bailey.
Thank you again for having me, Simon. Great to be here.
Bailey, all things contract. We sign a contract, we only look at the price, but the devil is in the detail in the clauses, and it can cost us the entire contract.
That is correct. The devil is in the detail, but we'll get into a bit of that later.
Okay, so if you stick with us, I'm going to have Bailey drill down on the technical problems in clauses in contracts that could cost you your deal. So let's start with the difference between standard conditions and special conditions, just so that we understand the terminology.
Well, Simon, standard conditions are the standard terms that would be included within a general contract, the usual ones being the REIQ standard contract terms. So they're usually in place to protect not only the seller, but also the buyer. The special conditions are a little bit different in the sense that they're clauses that have been specifically drafted by either the agent, the buyer, the seller, or the seller's representatives, or the buyer's representatives, and they usually take precedent over the standard conditions.
So the standard conditions are very important, but your solicitor should be well aware of them and explain any implication they have on your deal.
Correct, yes.
But it's the special conditions that we really want to focus on, and they're the bespoke clauses that are drafted specifically for your particular arrangement. Is that correct?
That is correct. Special conditions are usually drafted to reflect any sort of arrangement that are going on specifically with that purchaser and that seller. Some of those could be special conditions in respect of how the property is to be dealt with, how it's to be sold, how it's to be maintained, for example.
Now, I did hear you talking about the different people who can draft special conditions, and it triggered a real warning for me. Agents drafting special conditions. Is this a problem?
It is. We always recommend coming to see us before you sign a contract. If you need special conditions drafted, due to the fact that there is a lot of errors in some of the special conditions we're seeing from some agents.
So don't draft your special conditions yourself. Don't get your agent to do it, because as we've said, the smallest problem in drafting could cause an issue. It could be the use of the word shall compared to the use of the word may.
Correct.
Major difference.
Yes, massive difference.
And you don't know what you don't know, and that's why you should have a lawyer draft that, because they have been educated and experienced in the specific wording to use.
That is correct, exactly. And agents as well, for any agents listening out there as well, we take care of all the special condition drafting, so just feel free to give us a call. And for any of you buyers and sellers, please just give us a call before you sign a contract to ensure what has been represented to you is correct.
So Bailey, let's get into the specifics. Can you give me some examples of some special conditions and how they might impact our contract?
Well, whilst not special conditions, some of the other terms in a contract that are relevant for any buyer or seller is your finance condition, your building a pest, some of those conditions. Your finance condition is a clause that you have in your contract whereby it allows you, in the instance you need to purchase, to obtain finance. That's very standard, majority of our contracts.
And if I don't get my finance?
If you don't have your finance, as long as you have that finance clause in the contract, you can pull out at any time so long as that period hasn't passed.
And do I get my deposit back?
And you get back your deposit.
Fantastic.
Yes.
But it's got to be drafted correctly.
It has to be drafted correctly. Some of the errors I have seen previously is there's 3 boxes on that contract. If one of those boxes are missed, then that finance clause isn't valid.
Right.
Yeah. So you think you could be protected by it saying 14 days and the amount of lending that you need. But if it doesn't list your financier, then that contract, that term is invalid.
Okay. What other ones were you talking us through there?
One of the other ones is building and pest. That's a big one as well for anyone purchasing any property who needs to do any building and pest inspections, ensuring that you've got adequate time, 1, and 2, that you actually go ahead and do your building and pest inspection.
Okay, so could you talk us through some of the specific special conditions that might be drafted and how things can go terribly, terribly wrong?
Well, a few examples that I've seen previously, one of which being early possession of a contract, whereby the buyer's trying to get into the place of residence earlier. The way that that's drafted sometimes can mean something completely different to what the parties have had in store. An example of which we've seen is whereby some of the buyers think that they've got this clause in the contract where they can enter into the property early because they're property's being sold for whatever reason, and they actually don't have a place to stay because that special condition is incorrect.
So it could be, for example, a drafting that they've got access to store property, say in the garage, but they can't live in there.
Correct, yes.
They can't move in.
Yeah, exactly. That's exactly right. Some of the other ones we see as well is contemporaneous settlement clauses.
What's that?
Contemporaneous settlement would be whereby if you're a buyer and you're selling your house, that the settlement date of your proposed purchase happens on the exact same day as your sale.
Okay. And that's a tricky one because most people need the money from their sale.
Correct.
To complete their purchase.
Yes. So it's linked, but that is a very specific special condition. And the way that some of it's drafted may not accurately represent what has been represented to you.
What problems do you see with the drafting of that particular clause? Because that's really important, right?
Some of the specific drafting I'm seeing of that clause, especially at the moment, is whereby they've got a contemporaneous settlement clause, but in the instance one of those contracts gets extended, what happens? Whereby the special condition doesn't have consideration in the fact that if the seller's sale goes past a week beyond the date, that contract is null and void.
So what happens with their purchase?
They'd have to go ahead and they don't even have the money to do so.
And similarly, we see contracts that have a clause drafted saying it's subject to you getting a contract of your sale, but doesn't go far enough to say that it is also subject to that sale settling. So the money might not be in the seller's in their bank account to enable them to buy the next property.
That is correct. That's another big one we're seeing at the moment, whereby special conditions have been drafted that would outline the contract subject on the buyer's sale going through, or that's what's been represented to the buyer. However, the contract may state that the contract is only subject and conditional upon the buyer obtaining an unconditional contract.
So their sale doesn't go through. They don't have the money.
Yes.
They're in breach now?
They're in breach. Although that contract term says it'd be subject and conditional upon an unconditional contract, what if the purchaser on their sale doesn't go ahead?
If they default.
If they default, then you're at default. And then you can be sued by your potential seller.
So I can be sued on my purchase because I don't have the money from my sale and I lose my deposit.
Exactly.
This is the importance of getting these special conditions right, and the wording is important.
Yes, it could be is one full stop, the word may or must. That can mean the difference between you having a lovely settlement or whether you get sued later in court.
And let's talk about when the obligations and the risks arise on a contract. When does that start?
That's a great question, Simon. That actually happens the day you sign the contract. Obligations start from the very moment you put pen to paper.
So what sort of obligations might I be signing up for rather than just paying the purchase price?
Well, some of the things more than likely you'll have in the first initial period after signing the contract is you may have deposit due dates. If you don't make that deposit due date when the contract specifically says so, you're in breach. Another thing as well is your finance conditions. If you don't make those conditions, they're whereby the seller has a right to terminate. Other considerations as well may be anything in relation to special conditions, as we just talked about. But those are the kind of things that whereby as soon as you sign the contract, those obligations start right away.
So time is pretty important?
Time is of the essence in Queensland.
What does that mean?
Time of the essence means that due dates, specifically in relation to contracts, are the deadline. So whereby if you miss it by a day, you could be in breach of contract, where that date means it is due when it's supposed to be.
So it's an absolute guillotine. If I'm
Correct.
due to do something today, I pay a deposit and I don't, then I'm in breach and I could have serious ramifications.
That is correct, yes.
And a seller also has obligations from the day they sign, don't they?
Yes, they do. Some of the obligations, whilst it might not be known to as many sellers, would be certain things as maintaining your insurance. One of the things in that is, although the buyer is at risk of the property, typically the business day after signing the contract, sellers should still maintain their insurance, because what happens if the purchaser doesn't go ahead with the property and something does happen in the interim? Other things as well that a seller may not think of in the first instance would be things like keeping the property in a well-maintained condition and not trashing the place, just leaving rubbish there or not attending to the property as they usually would.
Well, thank you so much, Bailey, because what seems like a simple process of signing a contract where I am completely focused on the purchase or the sale price has made me now start to think that all these other terms and conditions are pretty important as well.
they're imperative that you get them correct. So we'd recommend before you sign a contract of sale or purchase that you come to us just to have a review beforehand. We can explain all the details and the intricacies of the contract to make it as easy as possible for you.
Thanks, Bailey. And I've got a question for you. If you're selling your property or buying one for that matter, are you certain, like 100% certain, that you know what all your contract clauses are and what they mean, and that the wording is actually right? Is your contract watertight? And if you're not sure, take Bailey's advice and give the OMB property law team a call, because we know the answers. Thanks for listening, and we look forward to seeing you next time on the OMB Law Board.